Good evening, ladies and gentlemen. Welcome to another exciting episode of the Paul Brown Show. We're taping live at To Expose You Studio. I have Mr. Dow Goodman. He's the founder. Mr. Ray Harvey, chief engineer. And I have, returning as my guest, I have Miss Tavia Watson. How you doing, Ms. Watson?
I'm doing wonderful, Mr. Paul. How are you doing?
I'm doing great.
Good.
Tell our audience a little bit about yourself again.
My name is Tavia Watson. I am from Richland County, Columbia, South Carolina, living in North Charleston. I am employed with Origin SC, where I am a credit counseling, housing manager, as well as a lead worker there as well. So today, me and Mr. Paul have decided to come on to talk a little bit about wills.
Yes, ma'am. We want to talk about will. That's something that's very important that we seem to take for granted. Why is will so important in our lives?
To have a will is important because it's a legal document that kind of outlines what you want to happen after you are deceased, after you die. Your will is designed to create a pathway as to what you want your wishes to be once you have gone on and your family is back here to kind of take precedence over your property and your assets.
Now, I know that we just had this pandemic that went on last year, and a lot of people died that probably didn't have wills. So what would possibly happen if you don't have a will to your property?
The question is always asked, how prepared can you be? If you don't have a will that's left to determine what happens, then your property, your asset will be in probate court. And what that means is probate court has to determine who gets what, whether it's a family member, whether it's a spouse or blood relative. How are they going to divvy out your asset or any property that you may have left after you've died?
I know we've heard a lot of arguments, fights goes on because of these wills that's been made up because of the families not getting what they want, the family member. How big is it of that paperwork?
It is very important to have a will. Oftentimes, if you don't have a will, it can cause a lot of confusion, heartaches, and pains between family members, just trying to disperse what is left. When you have a will, it kind of outlines again what is definitely your plan after you have your time has expired here. So it kind of alleviates any problems between loved ones. It alleviates any malice. It kind of just brings home exactly what you wanted your wishes to be, and where you want it to go after you have died.
Is it hard to make a will or to get a will made?
It is not hard to make a will. I do agree that you should definitely consult with an attorney to have a will, so you can understand the process and having a will and how a will is designed to be carried out. You could talk. A will is very inexpensive, depending upon what's in the will, whether it's a living will, whether it's a trust. But at the end of the day, a will definitely should be in place with an attorney so it can be a legal document and filed properly.
I know you mentioned something about a trust. What's the difference between a will and a trust?
A will is, like I said, it's a document that's legal. It's binding you to what you want to happen after you have died. A trust is more so a fiduciary relationship that you leave, and it can be formed whether when you're still living as well as your death. So what happens with the trust is, if you have any properties that you want to leave to someone, you put it in a trust form and you have a trustee over that account, and then funds or property is dispersed as directed.
So what are some of the conditions that must be formed when developing a will?
Some of the conditions is definitely your blood relatives. You have to take in consideration what asset, whether it's a savings, whether it's a property, whether it's a money market account. The deal with a will is to definitely be precise as to where you want what funds to go where. There could be a lot of difficulties deciphering between what you mean if it's not precisely written out, where an attorney is able to explain exactly where your wishes, what you wanted your wishes to be.
I know in some circumstances you may have more than one will because sometimes there's more than one family. You have there's that certain situation. Whereas the man may have another
Family.
Correct, and so they may have a will, and then his wife or may have a will, and now when he dies, there may be some type of confusion. How is that settled?
Well, if you have several wills, or if you have a will that was written, and whatever the last will states, the last to date will be the will that is honored. Typically, what happens with a will is once it's filed in court, the attorney, after your death, the attorney is able to read the will at any time. However, a will is public information where if it's filed in court, after a certain time, you're able to get a copy of the will and see exactly what it reads. Now, if the will is not outlined to be understood, then that's when it will be held up in probate court. Once it's filed and held up in probate court, it takes at least 8 to 12 months to decipher between how things would be dispersed and to act out the will accordingly. So then it'll be in the hand of probate to decide or make a decision as to where the funds should go or what should take place in reference to that will.
Okay, what about in a situation whereas who handles the funeral is described in the will? How would that be? As far as even who handles the money situation?
It kind of depends on how the will is written. That's why it's always good to be precise. There is an estate planning as well. And in that estate planning is actually where one or two things happen. It kind of gives precedent over things when you are unable to make decisions. But if you have a will that outlines how you would like your funeral arrangements or how you would like things to be handled accordingly as far as your preparation for eternity, then that will has to be mandated and taken out as your wishes. So typically what will happen is that will be read, and then from that point, wishes are to be granted upon whatever is in that will. Whether it's a funeral, whether it's who does the arrangements, how is it handled, who actually is going to be in charge, all of that should be outlined precisely in the will, so where it will be step by step, with no inconsistencies or questions about it.
With something as important as a will, why do we procrastinate as far as having one done?
Well, when you're talking about death, it always brings awe because it's something that we do not want to talk about. We're not comfortable talking about it. Speaking of death leads to other questions and other conversations. So a lot of people shy away from talking about their after plans, their plans after death, and what they want to happen once they leave. You have to be definitely comfortable in making those decisions. But it is a conversation and it is a topic that I do feel that most families should start talking about so that it could eliminate a lot of confusion, a lot of issues between families, and kind of just seal the gap between your wishes and well as what is going to happen after you have are deceased.
When a will isn't found Is there some circumstances whereas the state may come and take certain like property or stuff from that?
If a will is not found or if there is not a will, like I said, it is held up in probate. And probate has a process in where they determine the next kinship. If that next person or the next kinship doesn't do what is needed, oftentimes that property could be awarded to the state and sold through probate as just state property from the state. So I do recommend that if you do not have a will and you and family members are interested in knowing what their rights are, definitely seek the probate system so that you'll know what your rights are and know where you stand as it relates to what's due or what's owed to you from inheriting what was left.
I know we have a lot of the children that they leave and they go to like other states and all that, and they're not really keeping up to date with other family members that in a certain location, and that death happens, and they kind of like just lose contact, and then that death happens. So how does someone be able to contact those next of kin?
A lot of that information is public record. If it's not recorded, there is where you could open a file to have it researched or investigated. I definitely recommend getting resources as to what you can do if you're not connected or you're not familiar with the next kinship or how closely related or what you are able to obtain from a loved one that has passed on. Like I said, a lot of people don't realize that public records and records that's held in probate are for the public to kind of research and see where they are in line of like getting property, or if there's any money that may they've been inherited. There is also websites that you can kind of go on and see if there's any monies left, unclaimed cash that you are not aware of as well. But you just have to familiarize yourself and ask questions and become familiar with what your rights are and what you can do to get what's rightfully yours.
I know that on some of the bigger cases of the wills, like some of the cases like Anna Nicole Smith. Now, there was a case where she left a lot of that money to her daughter, and then they had to determine who was the father of that child in order for, in order for that person to be responsible for that child's.
Well, what I do know is that if you are a minor child and your parent, a loved one, passed away before you are the age of 18, your money is oftentimes your money is held in a trust where an agency or a conservatorship is over the money, and once you're 18, monies will be dispersed to you, typically because you have been left that money from a parent. Oftentimes, I wouldn't say it does not have to have anything to do with the other parent, but for the most part, if you are a minor child, the monies is held in a trust, and the child is able to get that funds according after they're at the age of 18.
And the person, like the guardian, the father, or
after they're 18, the guardian or the guardianship person is like null and void because they're of age.
But before, then they would
still have to contact the courts to ask the courts for permission to get some of the money to show what the need of the money is. So it's still where someone is over that trust due to the age of that child, whether it is a guardian that's there as well.
Like another big case that I think is the Prince estate. I think he has a lot of money, and there's a lot of things that's in there, and now family members are coming in trying to get part of that wealth because he has
A lot of money.
a lot of money. I mean, we're talking about a lot of money, and
That's when it gets kind of difficult. That's when it'll be years and years of investigation and years of proving rightfully who the money actually goes to. If you do not have a will and if you have a spouse, legally it transfers to the spouse, and then any biological kids. But it's like a trickle effect. The thing about it is just knowing your rights. Probate is where it's a lot of information in that system. It is good to kind of research and understand it, and then that way you would not be surprised if it doesn't go in your favor.
so when should you start kind of like getting that knowledge on wills and start preparing for?
Well, there's not a time frame because we can't determine the death of a loved one or when is your time. So any time is a good time to look into a will. I know a lot of people think that wills are more for older adults, older people. However, wills are good if you just if you feel like it's going to be a problem, or if you have an uncertain amount of money that you want to definitely be dispersed the way that you want it to be dispersed. It is good to look into at least speaking to an attorney to see what your rights are, to have that outlined so that it won't be a hassle for family members, or any type of misunderstanding or judgments when that time comes.
Okay, on certain like when you have beneficiaries, how would that be different than having a will?
Beneficiaries are typically where you are leaving someone an asset on a policy. So it's sort of different from a will. A will, like I said, is a legal document. However, a beneficiary is someone on like a policy where they may benefit from being listed as a beneficiary from a policy. So it's kind of different between a will and a policy.
So can you have like a beneficiary like on your bank account and things like that? I know we have like our insurance policy, we have like beneficiaries.
You can have beneficiaries on your bank accounts. If there is a discrepancy between the beneficiary on your bank accounts and the will, that's where, once again, after the deceased has died within that 8 to 12 months, once again, it falls back to probate. And that's when they'll determine who have the right of way or the leverage as to what is inherited from after the deceased has died.
I know this is a very important topics that we're talking about, that developing a will, because like I said, there's that asset that people have that we seem to think that's gonna create so much confusion, because when you die, people are going to fight over it.
The main key is for people not to fight over it.
We're going to fight over it. They're going. I mean, siblings, family members. They're going to fight over it. If they don't get what they want out of that thing, they probably going to fight over it because they want.
It is. There has been time when family members disagree on what's left, but if you are, like I said, if you are precise with your will and it's detailed and outlined, there shouldn't be an issue with what's left to me versus what's left to Johnny, or what's left to Johnny and what's not left to me. that is basically telling you what that individual wanted and where he wanted or she wanted it to go. So if a family member decides to argue or fight over a will and he's not named as the beneficiary in the will, it's typically out of the hands. Because your will is going to outline what you want. That's what it's designed for, to outline what you want. Now, a lot of family members may not agree, but then you can leave your property and your asset to who you like to leave it to. It's the problem when you don't have a will and then probate has to decide where it goes.
I know we talked earlier about, that other family, when that comes into the situation, and how do you deal with that, because that also is something that goes on a lot in our generation that we try to stay away from.
We do. A lot of people do have other family secrets that's not known, and unfortunately when death comes, a lot of things come out. Those are the things that we have to deal with accordingly, and I suppose once this dealt with, you make your peace with it and then you have to decide to move on. You only can get what's yours. So in that situation, I would hope that that will is precise enough to say where they want the monies to go or who get what, and then the person make peace with how it is and move on. When I say precise, I mean whether this portion goes to you, if it's a savings account, if it's a money market account, because you can lump all of that into one savings, and then if you don't decipher between it will be where someone has to, an attorney or judge has to decipher between which savings you're talking about. So if you're precise enough to say, I want my money market savings to go to Janet, and I want my regular savings to go to Chris, is a more precise measure. It keeps down on a lot of confusion. Is written out, and it has to be honored as it is.
We're running short on time. What are some of the other topics that you would like to discuss in the future so that to educate our audience?
One of the things that I would like to discuss in our future is how we could definitely better communicate as family members. One time back, family members was more loving and kind and caring. And now, so we've gotten away from being caring and loving between each other, and communication lines are definitely broken. Effective communication between family members is the key. So if we can kind of talk about ways on how we could strengthen our families to where the communication is more positive, more loving, more in tune, so that we can reunite more families, that would be an awesome topic.
Okay, well, we'll do that the next time. Okay, Ms. Watson, if someone wanted to get in contact with you, how would they go about doing that too?
Definitely. You can contact me at twatson@originsc.org, or you can contact me. The phone number is 843-628-4261.
And what is one last advice you would give our audience before we leave?
One last advice that I would give the audience before I leave is sit down and talk to your family members about the importance of a will. Sit down and talk to your family members about your wishes, so that whenever that time comes, you and your family members can all be on one accord. There will be no arguments, no confusion, no frustration, and you can make the end of your days the best of your days by knowing your family members are satisfied and everybody is fine. So if I had one last thing to say, be comfortable with discussing wills and how wills are handled, and what to expect. It is a hard topic, but it's a needed topic. It's needed for our families and for our children, because no one knows the day, the hour, the year, or the time that their life will end here on earth.
I'd like to thank Ms. Watson for coming on the show. I'd like to thank To Expose You. And I'd like to thank our viewing audience. And you be encouraged. Thank you.